35th year of the symposium of the North Idaho College Popcorn Forum and Convocation Series. We hope you'll be with us all week. It is an exciting week, and most of these topics are front-page stories around America at this time. Before we get into today's program, it's my pleasure to introduce to welcome you to this 35th year, the President of North Idaho College, Dr. Michael Burke.
Good morning. Good morning. There you go. It's our audience participation moment. I'm probably as thrilled as anyone for this morning to finally get here. I've been looking forward to this event all semester when I saw the topics to be discussed. And as Tony mentioned, they are front page news for all of us. I'm thrilled as anyone to be here for this opening of the symposium, with the possible exception of probably Tony Stewart, who is probably more thrilled than anyone that we've got this thing started, and Pam Noah in his office is probably equally thrilled to have us started. But on behalf of the faculty and staff and the Board of Trustees of North Idaho College, it's my privilege to welcome you to the 35th Annual Popcorn Forum and Convocation Series Symposium. That bears repeating. That's a 35th annual. I bet NIC is the only community college in America that can boast a 30-plus year history of celebrating the intellectual life of our country. This week, as you look through that program, you'll notice it truly is a Herculean accomplishment we can all be proud of as a community of scholars, teachers, and learners. For those of you who are experiencing your first Popcorn Forum, I have some advice for you. Please buckle your seatbelts and put your tray in the upright and locked position. You're about to take an exciting, challenging ride this week. You're about to meet an unparalleled cast of speakers. They are committed to addressing important, controversial, and often contradictory issues. Issues like free speech, civil liberty, national security, the right to privacy. For all of our speakers, these are not just buzzwords. They're an essential part of our American democracy. You're about to hear from experts such as Senator Larry Craig, Congressman Butch Otter, the U.S. Attorney for Idaho, Mr. Thomas Moss, as well as the ACLU Executive Director for Idaho, Mr. Jack Van Valkenburg. And that's just to mention a few. If you read through your program, you'll see a whole list of luminaries that are going to be part of this process. We have, looking through there, it struck me that we have an abundance of riches this week. We have dozens of guest speakers who are going to be meeting throughout the week and engage you in hot talk on important and controversial issues of today. I'd like to take a moment and give credit to the founding members of the Popcorn Forum. They began this event 30 years ago, and they chose a format of impassioned discourse, where divergent ideas like the ones you'll see in your program are about to be investigated and expressed and debated. This discourse is the heart and soul of the collegiate experience, and I hope each of you leave here this week enriched by this experience. I'd like to take a presidential liberty and take a moment to thank a few of the folks who make this event possible. We'll be here for quite a while if we tried to thank everyone, but first and foremost, I want to thank Tony Stewart. Tony, this has been a late... Thank you. Yeah. This has been a labor of love for Tony for at least 35 years. Also want to thank the Popcorn Forum Committee. These are folks behind the scenes who start probably next week to develop the program for next year. Also want to thank ASNIC, the Associated Students of North Idaho College. They have partially funded this event for a number of years. I understand 35 years ago, Tony was telling me they bought the first popcorn. So that contribution has been growing ever since, and they've helped to underwrite this process. Also want to thank some of the folks you'll never see, and they're in the background here, the NIC Theater Department, as well as the NIC Video Production Department, who are going to tape and make available everything that goes on this week. There are thousands, really countless numbers of volunteers out there from our faculty and staff and students who are also going to give freely of their time to make this event happen. And together, all of them make this symposium possible, and we are in your debt. Again, welcome. I hope you enjoy the journey. And now it's my pleasure to introduce our extraordinary student body president, Ms. Heather Erickson. Heather?
Well, welcome everyone. Basically, I just wanted to let you know that ASNIC is so proud to sponsor this event, and Tony does a wonderful job. This week will be full of thought-provoking discussions and hopefully enrich your experience here at NIC. So welcome and have a great week, everyone. Thanks.
I want to thank both presidents. That was very kind and thoughtful of them to do this. We'll get right into the program, and I want to say as we introduce today's program that we have 10 presenters over the next 5 days in the morning, one on each side of the issue, and I think in 35 years we've never had such outstanding experts on both sides. There was no weak presenters this week. They're all highly qualified, and I know you'll show great understanding and respect to them, and during the question period, any question asked, both our speakers during the week will have an opportunity to answer every question. Unfortunately, Congressman Otter had to be in Washington, D.C. yesterday and cannot be with us. But the good news is that, one, he has a representative here, and we also have his speech on tape. It will be 12 minutes long. I've viewed it, and it's very, very powerful, as our other speaker is that I'll introduce after this. So if you would welcome one of the administrative assistants to Congressman Otter, he will introduce the 12-minute tapes, which we'll play. Would you please welcome his assistant, Mark Compton.
Thank you, Tony. I would like to apologize that Congressman Otter could not be here in person. His schedule just simply wouldn't allow it, but he did want me to come along and introduce him and the videotape and to be here for when you have the comment portion of this, to take notes and get those back to him with any comments and or questions that you might have for him. Congressman C.L. Butch Otter is a proud father of 4 and grandfather of 2 who lives on a ranch in Star. The Idaho native and son of a union electrician, was the 6th of 9 children and grew up on a Canyon County dairy farm. You know, some people wonder what the CL stands for and why he's called Butch. Well, CL stands for Clement Leroy. And I said he's the 6th of 9 children. And he likes to say that by the time his parents got to him, they ran out of the good names. So that's why he goes by Butch now. But Congressman Otter received a bachelor's degree in political science from what is now Albertson College in Caldwell, and he served honorably in the 116th Armored Cavalry of the Idaho National Guard, the same group that is serving so honorably in Iraq right now. He had a 30-year business career where he rose to the presidency of Simplot Livestock and Simplot International. Politically, Congressman Otter served 2 terms in the Idaho House of Representatives and was the state's only 4-term lieutenant governor, serving with 3 different governors. In November of 2004, he won a 3rd term representing the people of western and northern Idaho in Congress, where he's a champion for individual freedom, personal responsibility, private property rights, and state sovereignty. The congressman serves on the House Committee on Energy and Commerce, where his subcommittee assignments include commerce, trade, and consumer protection, energy and air quality, and environment and hazardous materials. He's also the Assistant Majority Whip, and he works closely with the leadership of the House Western Caucus as well. Specifically in regards to the Patriot Act, the congressman gained a national reputation early on. He was a freshman member of the House of Representatives in 2001, and when they passed the Patriot Act in the immediate aftermath of 9/11, the congressman was one of very few voices in opposition to the act. I'd like to just briefly, because I know that the congressman is going to focus in his videotape on some of his proposed solutions to what he feels are some of the problems with the act. I'd like to read for you his floor statement and back in 2001 during the debate on the Patriot Act. He was the only Republican to actually get up on the floor of the House and debate against it, one of only 3 to vote against the act. I quote, "I fully support the efforts President Bush, Governor Ridge, and Attorney General Ashcroft have been undertaking to increase our security protections. Many of the provisions of this bill are necessary steps to protect the public. Some of the provisions, however, place more power in the hands of law enforcement than our founding fathers could ever have dreamt, and severely compromises the civil liberties of law-abiding Americans not engaged in subversive activities. We must not allow the first non-human casualty in the war against terrorism to be our civil rights. Therefore, I cannot in good conscience vote in favor of this wide-reaching legislation. When we give the government the right to limit our civil liberties, it must be carefully and narrowly defined, because once given, those powers are nearly impossible to take back. I support my president, I support law enforcement, but I also support the fundamental rights and liberties of the American people. This bill, while crafted with good intentions, is rife with constitutional infringements I cannot support. So that kind of gives you some background on what happened in 2001 with the passage of the act. Now I'd like for you to watch the video presentation that the Congressman has prepared, where he will discuss some of his proposed solutions. Thank you.
The September 11, 2001 terrorist attacks on our country demonstrated that America's defenses were inadequate for the new threats that we face. President Bush and then Attorney General Ashcroft asked Congress for new powers to interdict and prosecute the increasingly decentralized terrorist network operating in our country. I agreed that some of the new powers requested were necessary and supported large parts of the Patriot Act, which were passed just 46 days after the 9/11 attacks. However, some of the provisions of this legislation cannot be justified even in the face of new threats. For instance, the Patriot Act dramatically expands the use of no-knock, delayed notification searches of private residents. This provision threatens the protections afforded us by the Fourth Amendment by making it a rule rather than an exception, allowed only under special circumstances, to allow the government to search a private home without ever informing the residents that they were the targets of an investigation. Another section of the Patriot Act significantly lowers the standard for court oversight, allowing the FBI to obtain business records from financial institutions without showing any court approval. In addition, the definition of financial institutions has been expanded so that travel agencies, car dealerships, and even the United States Postal Service are the subject to these administrative subpoenas. Perhaps the most far-reaching provisions of the Patriot Act are those that affect the Foreign Intelligence Service Act, or FISA. FISA orders are issued by secret courts and previously were restricted to cases in which the sole purpose was to obtain foreign intelligence information. They were expanded under the Patriot Act to allow the government to gather intelligence on Americans without the protection of probable cause. In addition, the Patriot Act authorizes the government, again with permission of a secret court, to seize the business records of any business establishment in the country, and then order the proprietor not to inform anyone that the records had been seized. These changes grant vast powers to the federal government with the dangerous potential of denying fundamental freedoms to American citizens. Now, during my time in Congress, I have continually supported taking thoughtful and balanced measures to strengthen our national security and protect Americans from the vicious attacks by those who oppose freedom and wish to destroy our way of life. However, these particular provisions of the Patriot Act have the intended effect of harming the very liberties that we set out to preserve. In response to my deep concern about the way that we have expanded the government's power over the individual, I will soon be reintroducing the Security and Freedom Insured Act, more popularly known as the SAFE Act. The SAFE Act would continue to provide law enforcement with the tools necessary for winning the fight against terrorism while safeguarding the freedoms of American people. It addresses a few particularly controversial provisions of the USA Patriot Act that permit federal law enforcement to survey Americans without adequate oversight from the courts. I am particularly concerned about how the Patriot Act expanded the powers of government to conduct sneak and peek searches. Many advocates of this provision have tried to comfort the American people with soothing talk about how this power is rarely used and has certainly never been abused by federal law enforcement officers. The issue at hand, however, is not where or when or even how often these warrants are used, but rather that the government possesses these broad and sweeping powers at all. Now, I have no doubt that the Patriot Act sneak and peek provisions were well intended. However, Americans can only feel truly safe if their freedom and liberty is secure. Of course, sneak and peek warrants were used before the passage of the USA Patriot Act, and I recognize that the courts have upheld their use in limited and extraordinary circumstances. But this does not justify the serious steps taken in the Patriot Act to erode our Fourth Amendment protections. By broadening the use of sneak and peek warrants and making them the standard rather than the exception, the Patriot Act threatens the liberties that we are granted by our Creator and then protected by our Constitution. The SAFE Act narrows the scope of sneak and peek and restores the checks and balances that were built into our Constitution. Where the Patriot Act allows for more delayed notice of search warrants in any and all circumstances, where notification would seriously just jeopardize an investigation or unduly delay a trial, the SAFE Act more carefully defines the very specific circumstances which a sneak and peek warrant can be used. In addition, it employs the more concrete notification procedure upheld by most courts before the Patriot Act, rather than delaying the notification for an ambiguous, reasonable period of time. If we are going to codify this questionable tactic of delaying notification of searches, shouldn't we at least limit it to the practice previously established by the courts? The SAFE Act also restricts the government's ability to obtain business records under a FISA order from a secret court. It allows the government to request records from anyone, but it requires specific evidence that the records sought belong to a person who is believed to be a foreign power or an agent of a foreign power. It no longer would allow the government to seek records concerning just any person. By making all businesses subject to a FISA request business records, the Patriot Act also makes libraries an adjunct of government and thus threatens the First Amendment rights of all Americans who use libraries for research, education, and for pleasure. The SAFE Act removes libraries from being considered providers of wire electronic communication services under the law, requiring such providers to surrender information at the request of the FBI. Through this common sense approach, we ensure that our constitutionally protected freedoms are restored without jeopardizing the ability of law enforcement agencies to effectively fight terrorism and crime. The SAFE Act takes this same common sense approach with another egregious provision of the USA Patriot Act. One section now allows the secret FISA court to issue wiretap orders without information regarding the third-party carrier. Before the Patriot Act, FISA orders were required to name not only the suspect holding the conversation and the person he or she was communicating with, but also to place the mode of communication, whether it be a specific room in a hotel, a particular phone booth, a certain cell phone number, or one telephone company. Since the Patriot Act was adopted, surveillance orders need not be limited to specific carriers, only to the person being tapped. The idea is to defeat the attempts by the suspects to thwart surveillance by changing hotel rooms or cell phones or their numbers. However, the language leaves American citizens vulnerable to government agents who, intentionally or not, may disregard their rights and freedoms and infringe upon their privacy with dangerous results. The SAFE Act addresses this so-called roving wiretap authority in two ways. First, it requires that either the target of the wiretap or the nature and location of the facilities be identified in court orders. Second, it would only allow for the electronic surveillance of a location when the target of the surveillance is present. Those of us serving in the 109th Congress will have the opportunity to revisit some of the Patriot Act's more dangerous provisions this year. Whatever other errors they might have made, the bill's authors were wise to include a sunset provision, which means that some of the sections granting federal law enforcement or intelligence officers greater search and surveillance powers will expire on January 1st of 2006. This then gives members of Congress the chance, with more objectivity and perspective than we had in those weeks following the 9/11 terrorist attack, to restore some of the freedoms threatened by the Patriot Act. It is vital that Congress take the time and the effort to consider these issues in a more thoughtful and deliberate way. Unfortunately, not all of the most egregious provisions of the Patriot Act are set to sunset at the end of this year. So the SAFE Act adds the following sections to sunset, meaning that they will no longer be part of the law. after January 1, 2006. Section 213, which delays notification of search warrants. Section 216, which addresses the pen register and trap and trace devices. Section 219, which allows the use of nationwide search warrants in terrorism cases, and Section 505, which makes a large number of businesses subject to national security letters that allow the FBI to obtain business records without any court approval. The SAFE Act would also modify the definition of domestic terrorism. The Patriot Act created a definition of domestic terrorism which had been undefined under federal law. The federal crime of terrorism previously was defined by specific acts. However, under the Patriot Act, domestic terrorism is defined far more broadly as any act dangerous to human life that is in violation of state or federal law. It is not too difficult to imagine such a sweeping definition enabling prosecution of someone engaging in certain acts of civil disobedience or protest. The SAFE Act would bring the definition of domestic terrorism in line with what already existed in federal law. As Americans, it is our fundamental belief that each of us ultimately is responsible for safeguarding our own personal freedoms. It is our obligation, our duty as citizens of this great nation to see that no one is allowed to take them away, not even our own government. We would be justifiably enraged if some individual or group acted to destroy our Constitution all at once, to wipe away in one terrible calamity the centuries of struggle and countless lives sacrificed in the winning the liberties we hold so dear. My friends, it is equally important that we jealously guard against allowing our freedoms to be chipped away piece by piece before our eyes. That we do all we can to hold back those small but insignificant strokes of tyrannical erosion that eventually can determine and undermine the strongest foundation. I'm not the first to have these concerns, and those before me have said it more eloquently than I could ever hope to. James Madison recognized the importance of guarding our individual liberties with constant vigilance when he said, quote, "Since the general civilization of mankind, I believe there are more instances of abridgment of freedom of the people by gradual and silent encroachments of those in power than by violent and sudden usurpations." Ben Franklin warned, quote, "that they who give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety." And my great hero, Thomas Jefferson, cautioned against relinquishing our, quote, "inalienable rights to even a well-meaning government. Free government," he said, "is founded in jealousy and not confidence. It is jealousy and not confidence which prescribes limited constitutions to bind those that we are obliged to trust with power. In questions of power, then, let no more be heard of confidence in men, but bind them down from mischief with the chains of a constitution." Americans have a right to security, not only in their persons and their property, but in their civil liberties as well. I am hopeful that we can work together in the upcoming months to pass the SAFE Act and offer security to the American people without changing the essence of what it means to be an American. Thank you.
Mark, would you be so kind as to thank Congressman Otter for his presentation and being a part of the Popcorn Forum, please? Mark will be here, too, to take notes and share with the Congressman. We're equally pleased to have as our second speaker today a very distinguished Idahoan and American, Thomas E. Moss. I met him yesterday, and I can tell you he's a man of great integrity and also great cooperation in discussing issues. He is presently the United States Attorney for the District of Idaho. Every federal district court has a U.S. Attorney appointed by the President, confirmed by the Senate. He's a graduate of the University of Idaho College of Law in 1965. He practiced law and then became prosecuting attorney for Bingham County and served in that capacity for 25 years. From February 2000 until his appointment as the U.S. Attorney in August 2001, he served as a member of the Idaho House of Representatives. He has graciously agreed to come today to speak from his viewpoint as the U.S. Attorney, the importance of the Patriot Act. Would you please welcome Mr. Moss?
Thank you very much. It is truly a pleasure to be with you, and I especially thank Tony for his many kindnesses. Yesterday, my flight from Boise was delayed by over an hour, and all I knew was that when I arrived at the airport here, someone would be there with a sign that said North Idaho College. And I was saying a little prayer as I got off the plane that someone would still be here with that sign, and sure enough, as soon as I came into the public area, there sat Tony with a big smile on his face and his little sign, and it was a pleasure to meet him and some relief. Yogi Berra once said, "The future ain't what it used to be." Anyway, I have enjoyed that experience of learning what has changed in the recent part of my life. I became United States Attorney on August the 18th of 2001. 3 weeks later, the events of September 11 occurred. And one of the things about becoming United States Attorney, after being an attorney in a small town in eastern Idaho and being a small county prosecuting attorney, is I learned that your travel experiences are changing quite a bit. In my day in Blackfoot, if I had a case that took me to Preston, that was considered quite a lengthy trip away from my office. Now, and particularly following the September 11 events, I find that I travel a long ways each time. I go to Washington, D.C. quite regularly, and one of the things I experienced early on in that experience was how often I was searched at the airports. I mean, personally searched. And I don't know what it is that attracts the security people to me, but they certainly are. And I came back one day after returning from Washington, D.C., and I told my wife, Bonnie, I said, you know, just from D.C. to here, I was pulled out of the line and searched 3 times just on my return flight. And she says, well, Tom, tell them who you are. I says, what? Tell them you're the United States Attorney. Oh, I'm not going to do that. She says, you tell them you were appointed by the President of the United States, you were confirmed by the United States Senate, and you have the highest security clearance they give anybody. You tell them that. You tell them. I said, I'm not going to do that, Bonnie. Well, the next day, I had to fly all the way from Boise to Pocatello. And you can almost drive it faster giving the wait at the airport. But I went out to the airport and I thought, I've got a seat on the aisle near the front of the plane. I'm going to wait until everyone's on, and then I'll just slip right through and they won't have to search me. And so I did that. And after everybody had gone onto the plane, I waited, and then I went up. I presented my ticket, and the nice lady that accepted my ticket said to Mr. Moss, would you step right over here for a minute, please? And so I went over there, and a young man took out his wand and was doing his thing, had me raise my arms, and he's going over, I'm doing my belt, checking everything. And as he was going up this part of my body with the wand, it beeped when it got right to here. He says, what's that? Well, I had a lapel pin that was given to me by the agent in charge of the FBI concerning the Salt Lake City Olympics. And it had in one little circle, it had Salt Lake City Olympics, and in another little circle, it had Federal Bureau of Investigation. And he looked at that, and he got up close, and he read, Federal Bureau of Investigation. Are you with the FBI? I said, no, I am the United States Attorney. And he paused a second and said, oh, would you raise your arms a little higher, please? That's a true story, by the way. I didn't make that up. I couldn't make that up. At any rate, the world really did change on September 11. Shortly after that event, on one of the trips to Washington, D.C., all of the United States attorneys were called to Washington. And while we were there, we were called to a special meeting in a rather small conference room. All of the United States attorneys were there, and then and we didn't know this was what was going to happen, but the President of the United States walked into the room and took the podium and spoke to us for about 30 minutes. And I'll never forget what he said during that time. He said that in previous terrorist attacks on America, such as the World Trade Center attack bombing in 1993 and the federal building bombing in Oklahoma City, we considered law enforcement successful if it did a good job at sifting through the rubble, finding necessary evidence, and apprehending the culprits. He went on to say, but in light of what transpired on September 11, the capacity of the terrorists, the capability of the terrorists, the number of lives lost, and the clear willingness of our enemies to die for their cause, it is no longer acceptable that we simply be good at sifting through the rubble after the fact. He said we must become better at preventing terrorist acts from occurring. The President told us it was law enforcement's responsibility to do everything constitutionally permissible, and I emphasize his words, to ensure that September 11th does not happen again. Now that may seem like a rather logical and expected thing to be heard, but for a prosecutor, a career prosecutor like myself, you can't imagine what a change in thinking that involves. I have always considered our job to catch people who have committed crimes, bring them in, prosecute them, and hopefully punish them sufficiently that it will have a deterrent effect on other people. But the President is saying that's not good enough anymore. I recalled an experience that happened in Blackfoot when we'd been having a series of business burglaries, and we were told we were wondering who was committing all these burglaries, and then one day we get an informant that tells us, hey, we think we know who's doing it, and he's going to commit a burglary tonight. And it was going to be an auto parts store in downtown Blackfoot. And so what do the police do? They set up a perimeter around the area, and they wait. And sure enough, along about 2 o'clock in the morning, here comes the fellow down the street. And he walks into the alley next to the auto parts store. And they hear glass break. And they wait a little longer. And then they slip in the alley. They see that the window's now broken out. And it appears that entry has been made. So then they converge on the store. They find the fellow in the store with a bag with his goodies that he's gathering up to take with him. And they bring me that case. And I say to them, I can win this case. And it was a success, and we did. And he was sent to prison. And we had the result we sought. But now I'm being told that's not good enough when it comes to dealing with international terrorism. Disruption has got to be the goal in the case of international terrorism, and information is the key. We learned something on September 11, particularly from Flight 93. I left my water. Thank you. Flight 93 was the flight that originated in Newark, New Jersey, bound for San Francisco. It was the plane that eventually crashed in Pennsylvania, in a field in Pennsylvania. That flight was delayed at the airport. After the passengers were on the plane, it taxied out onto the tarmac, and it sat there for more than 30 minutes before taking off. It took off, it headed west, and at a certain point, some individuals in the first-class section stood up and with box cutters walked over to the flight attendant, the male flight attendant, and grabbed him and cut his throat in front of the other passengers. And you know the rest of the story. That plane was brought down by the passengers. And people have said what a courageous group of passengers they were, what great patriots they were. They saved that plane, probably was bound for the Capitol or for the White House. But what great folks they were. Often they overlooked one very important thing when we talk about those passengers. And that was they had something that the passengers on the other three planes didn't have. A very important thing. They had information. And how had they gotten that information? After the plane had been hijacked and the pilots had gone into the cockpit and killed the pilot and co-pilot and took over the flight of the plane, the two remaining terrorists, and there were only 4 terrorists on this particular flight. There were 5 on all the others. The 2 remaining terrorists herded the passengers to the rear of the plane and let them do what they wanted to do. And they used their cell phones and they made phone calls. They made more than 30 phone calls. The terrorists in the plane didn't know they were on a suicide mission. Osama bin Laden himself told us that. In a video later, he says the brothers inside the cabins didn't know they were going to be killed. And so they didn't care that the passengers were using their cell phones. In fact, they told the passengers, this is a hijacking, and we're going to land the plane later. Well, they used their cell phones. They found out about the other crashes, and they took the plane over and brought it down. Disruption is the goal. Information is the key. The Patriot Act came into being, as has been said, a short time after September 11. I just want to make a few general observations about it. One, it was a work in progress before September 11. In fact, it had been various parts of the things that became part of the Patriot Act had been in discussion for several years to upgrade our ability to investigate international terrorism. That's one observation I'd like to make. Another I'd make is that the Patriot Act would have become law regardless of who was elected president in that election. I am convinced of that. And number three, much of the Patriot Act would have become law even if September 11 had not occurred. Not all of it, because some of the things that are in the Patriot Act are specifically relate to September 11, such as setting up methods to compensate the victims' families of the September 11 attack. Also, there's, included in the Patriot Act, laws that relate to prosecuting people who discriminate against Middle Eastern citizens of this country or residents of this country. But let me talk just very briefly about some of those provisions of the Patriot Act. And I'm not here to sell anything. I'm not here to diminish anything. I'm simply here to explain and answer questions, hopefully. One of the things they don't like U.S. attorneys doing is becoming involved in legislative issues, and we try to avoid that. But we feel an obligation to at least let people know what is happening as far as federal law is concerned in terms of law enforcement efforts. Probably one of the most significant things that happened in the Patriot Act has to do with the Foreign Intelligence Surveillance Act, the FISA law. This was a law that was adopted a number of years ago that determines and dictates and delineates how America will go about spying on its enemies. It's the spy law, if you will, Foreign Intelligence Surveillance Act. And it provides the mechanisms we will use. It's interesting that many of our enemies that we are spying on have no rules, but we do, and we live by those rules. But that's the act. On the other side of the coin, we have criminal investigation procedures that are going on in the country. Now, because of the different standard in the investigative procedures that take place between foreign intelligence surveillance or intelligence investigations and criminal investigations, a wall was created between the two. And you've heard reference to this wall in the news in recent years. Now, what that was all about, that was that intelligence investigative information cannot be shared with criminal investigators. There's a wall there, and vice versa. Information that is obtained in grand jury investigations cannot be transferred over the wall to intelligence investigators, primarily the CIA. Well, after September 11, there was a lot of talk about connecting dots. Should we have been able to foresee the comings of the September 11 attack? Well, one of the things that made it difficult to connect those dots is the intelligence community was not allowed to tell the criminal community what they knew. Louis Freeh, the director of the FBI under President Clinton, shortly after September 11, made the statement that if the CIA had learned under their FISA investigations that September 11th events were imminent a few hours before they occurred, there would not have been time to declassify that information in time to turn it over to the FBI so these people could have been arrested without breaking the law. The Patriot Act removes some of the bricks from that wall to allow information to be exchanged back and forth between our intelligence community and our criminal community. Other areas I'll talk about, and I'll skip through these rather quickly, is the roving wiretap. Congressman Otter mentioned roving wiretaps. Basically, what a roving wiretap is allowing the judge, when he is being asked to issue a wiretap, to tell the police they can focus on the individual who they are investigating as opposed to a specific telephone number. In 1986, the United States legislature adopted roving wiretaps, and they allowed for them in investigations of organized crime and in drug investigations. It was determined at that time that these people had become more sophisticated than when the law had been adopted 50 years earlier, at a time when we used rotary phones and every family had one telephone. We are now in the cell phone era and the digital phone era, and organized criminals and drug dealers had learned to use cell phones and use them for a limited period of time, discard them, and use another one, which made it very difficult for the investigators to intercede into these criminal activities. And so in 1986, we adopted a law allowing for roving wiretaps in those two limited circumstances. The Patriot Act, what it does is expands it and adds another circumstance. It allows the use of roving wiretaps now in terrorism investigations. You know, I marvel at, 50 years ago when that law was adopted, I lived in a family of 8 people. We had one telephone for our family, one rotary telephone. I now live with just my wife and I. We have 5 phones. Count them. The world has changed, and so must the law if the police are to be at all effective. Delayed notice search warrants, or what is commonly often referred to as sneak and peek search warrants. These have been happening in the United States for decades. For decades. Judges, and this is not because of legislation, it's because judges have said under certain limited circumstances, the police should be allowed to not notify the party whose property they're searching ahead of time or at the time of the search, but to delay it. It's never delayed indefinitely. It's simply delayed for a reasonable period of time based on whether the judge determines it should be. And why would you ever need to delay notification of somebody that you're searching their property? I served as a county prosecutor for 25 years. I obtained hundreds and hundreds of search warrants during that 25 years. One time, I asked the judge to allow me to delay notification to the individual. And that was to plant a listening device into an area where we felt we had probable cause. The judge agreed to discover information relating to a serious crime. Now, I don't think it takes a rocket scientist to determine that if you're going to tell somebody you're going to plant a listening device in their apartment, you just as well save yourself the trouble. It's not going to be effective. But there are times, and in the terrorism context, let me give an example. If the police are informed that a terrorist cell has built a bomb, and they have planted that bomb somewhere in the community, and they're simply waiting for the most opportune time to detonate that bomb, and your informant tells you they've been meeting in this apartment late at night, and they have maps and they have schematics that show what they were doing. Well, we would go to a judge and we'd ask for a search warrant to go into that apartment and try and find information that might lead us to find that bomb. And we would ask the judge, allow us to delay notice, because we are convinced that once they know we're onto them, they will detonate the bomb before we can defuse it. That would be one of those limited circumstances when you'd want to delay notice. And those things have been allowed. In 1979, in the United States Supreme Court, in a unanimous decision in a case called Dahlia, in response to a criminal defense argument that the delayed notice in that case was unconstitutional, the United States Supreme Court at that time, that was in 1979, says the argument is frivolous. There are times when delayed notice is a very proper and appropriate police tool, and they need to be allowed to use it. The Patriot Act simply codified what these various courts have ruled all around the country, and it has been something that's always been upheld by the courts, but there was always a different set of guidelines and rules. And the Patriot Act simply brings it together and makes it uniform and provides a more understandable system to operate under. Another area that is quite important and has received a lot of attention is the area of obtaining business records. Now, this is a very much misunderstood section of the Patriot Act. It's Section 215 of the Patriot Act. And it talks about using a FISA procedure. That's this is the spy procedure, the Foreign Intelligence Surveillance Act procedure for obtaining business records. And we've heard this referred to as they go to secret courts and get this information. And these secret judges issue these warrants. Well, as a matter of fact, the court isn't secret at all. The procedure is secret. Because when we're dealing with enemies that would destroy us, it is important sometimes that we not let them know what we are doing and what we are learning about them. And so we're allowed to use FISA courts. FISA judges are the federal district judges that we all know and love that live right here among us. It's just that from time to time they receive a special assignment to act as a FISA judge, and therefore they are required to keep their procedures secret. And that's what's going on. Well, under the Patriot Act, FISA procedures can be used to obtain business records. Thus, we can keep that information secret for a time. We still have to go to a judge. We have to get a court approval to get it. And every time we use it, 6 months following, every 6 months, the government is required to report to Congress the numbers of times they have used those FISA warrants and the details of why they have used them. There is that additional protection. Now, let me tell you what we did before the Patriot Act. And I can use an example. You've all heard of the Unabomber. The Unabomber was operating for quite some time under the title Unabomber. Nobody knew who he was. And the FBI was doing everything they could to determine his identity. Well, he published a document called the Unabomber Manifesto. And in it, he identified 4 publications that people who wanted to become involved in anarchy should read. It'll teach them a lot of stuff, how to make bombs and how to assassinate government leaders and all of these wonderful things that anarchists need to be able to do. And these were not books that you're going to walk down to the local bookstore and buy. They were very unique. And the FBI learned that the Unabomber's been hanging out somewhere out here in the Intermountain West. And that he probably has read those books. And so they obtained a grand jury subpoena. And they served it on the library at Northwest University, on the library at Brigham Young University, on the library at the University of Utah, on the library at Montana State University, and the library, county library, Missoula County Public Library. In the process of that investigation, they found that a man named Kaczynski had checked out 3 of those volumes. And you know the rest of the story. Now, some may say, wow, that is really government overreaching to go into libraries and find out who has read certain books. And others of you may say, no, that's just good police practice. But I'm here to say, for our discussion today, it doesn't really matter because that all happened outside of the Patriot Act and can still happen today. What I'm simply pointing out is the Patriot Act in the area of public records actually has a higher burden on the government than we can do without the Patriot Act. And by the way, to get a grand jury subpoena, how do I get a grand jury subpoena as U.S. Attorney? I walk down to an office and open a drawer, and there's a subpoena there that has been issued in blank by the clerk of the court. I fill it in, and serve it. No judge sees it before it gets served. Now, I'm going to get in trouble if I misuse it, but that's the procedure that's available outside of the Patriot Act. And it's no wonder that the FISA sections of the Patriot Act get used very, very seldom. And they've never been used in the context of a library, which is something we've heard a lot about. It just hasn't happened. At any rate, one of the good things we have going as of right now is the Patriot Act has been in effect for 3.5 years. It has been very carefully scrutinized that entire time. There have been various speeches given, a lot of arguments made that the Patriot Act violates our civil liberties. But I'm here to tell you there has not been a case where a judge has ruled that someone's civil liberties have been violated as a result of the Patriot Act. If the Patriot Act, one of the things the Patriot Act does, and particularly with reference to this Section 215 we're talking about, is it says that if anyone, number one, you've got to make this report every 6 months if the government uses it. Number two, if someone claims their rights have been violated by the use of these provisions, they have the right to sue the government. There is no governmental immunity, as in most cases. It's gone for these purposes. They can sue the government, and damages will be assessed at least $10,000 plus attorney's fees if there has been a violation of civil liberties. There's an interesting statistic relative to that section of the code, that's Section 226 of the Patriot Act. Not only has no one never recovered a dime under that provision, there has been no lawsuit filed under that provision. And so the argument that the Patriot Act is violating people's civil liberties goes a little bit wanting in terms of the actual facts. In conclusion, I'll mention, not too long ago there was a hearing before the Senate Judiciary Committee. And since that hearing, I've talked to Senator Orrin Hatch, who at that time was chairman of the committee. He says, we've held 18 hearings on the Patriot Act, and not one person, we've asked every time whether someone's civil liberties have been violated because of the Patriot Act, and so far, not one report has been made to us. In this particular hearing, Dianne Feinstein, the senator from California, who, by the way, was no champion of John Ashcroft. She was one of the people that voted against his confirmation. She said in that hearing, and I have the transcript, she says, I received to date 21,434 complaints about the Patriot Act. And she says, I had my people check into those letters. Half of them had nothing to do with the Patriot Act, had to do with other laws that people had heard were going to be adopted or something. She says, half of them were thrown out. He says, then the other half were divided into two groups. One had to do with the detainees at Guantanamo, which is totally unrelated to the Patriot Act. Patriot Act has nothing to do with what's going on at Guantanamo. And she says the rest of them had to do with a system of requiring international aliens in the country of being fingerprinted and going through a process. She says that is not provided for by the Patriot Act. She says by the time I was finished, it was determined that none of those letters actually addressed the Patriot Act. And then she said this. She says, I've never had a single abuse of the Patriot Act reported to me. My staff emailed the ACLU and asked them for instances of actual abuses. They emailed back and said they had none. The Patriot Act, and I agree with Congressman Otter, we need to be very careful how we move in this area. I agree so much with that. We don't want to become alarmed and adopt laws that are oppressive and take away our civil liberties. I would suggest that the Patriot Act does that. It does not overreach. It has provided many protections that we needed, and I'm here to tell you today that America right now is at a 30-year low in crimes of violence. We've never had another attack on American soil since 9/11. Much of what has been able to be done under the Patriot Act has resulted in disruption of activities that have gone on in this country and abroad. And I think that America is a safer place today because we have the Patriot Act in place. Thank you very much.
I know some of you have to leave for class at 11 o'clock, and we understand, but we have a microphone down here just below the stage, and we're taping this, so we'd like for you to come to the microphone and state your name and ask your question. We have about 10 minutes for that, or 15, and then we have another function at 11:30. Let me also, before you leave, remind you that tomorrow's program at 10:30, there's an addition to that on your program at 11:30. We'll have the Idaho Press Club here to do a debate so we have two tomorrow at 10:30 and 11:30. We welcome you to the microphone if you'd like to come right here, please, and state your name, and Mr. Moss will address your questions. Please, right here, and state your name and your question, and Mr. Moss.
Hello, sir. Thank you for a good talk. My name is Richard Randall. I'm a retired Army officer, and I teach philosophy here at North Idaho College. And I agree with you. I've been in situations where secrecy and intelligence are of vital import. I held an interim top secret clearance during Desert Storm because I was stationed in the Pentagon, and I had to go through a vetting process. So there's no question that we need secrecy when we're being attacked. But I want to give you an example of what I consider an abuse where federal officials were using the Patriot Act to do something that had nothing to do with 9/11. A few months ago, federal officials went to the University of Washington Library, and they demanded access to all of Senator Henry M. Jackson's documents, his paperwork. Senator Jackson died in 1983. And what they said they were looking for was any information that could help them with respect to intelligence, because Senator Jackson had been on both the Armed Services Committees and also the Standing Committee on Investigations. Now, obviously, it wouldn't have been investigations on either, well, certainly nothing to do with the latter years, himself being dead. When the librarian was given the documents back, those officials had taken heavy black markers and had started removing, or had already completed removing, many names out of those documents 20 years prior to anything that's going on now. Now, you've already made a good case, and I agree with it, about why judges and courts can issue subpoenas, et cetera, et cetera. But this seems to me like more of an abuse than it does intelligence gathering. Would you respond to that?
Well, it seems that way to me also. I have a difficulty justifying anything like that if that's the whole story, which I assume it is. One of the things that we have to accept is, number one, we can't throw away a law because there are people who will abuse that law, and that's often a thing that we hear. We have to operate, I think, in this country on the premise that our government is going to be honorable and going to be honest. That doesn't mean it's always going to be the case, but if we go outside of that premise, things are worse than they would otherwise be. But no, I can't. Based on what you're telling me, I could never justify that.
Thank you.
Other questions? Anyone else? Yes, sir.
Good morning.
In Virginia, and two, more outspoken. Their links, of course, were with Philadelphia, Gouverneur Morris, other people like that, and they were increasingly outspoken in their opposition to slavery, and increasingly were seen by their neighbors as a sort of a fifth column. And in the early part of the 18th century, they were ostracized sufficiently that they picked up almost to a person and moved out. Some of them moved due north to Philadelphia. Others veered off to the northwest and settled in Ohio, northeast Ohio, in the case of my ancestors. As a I have that historical link to the period, and thus all of this was very, very interesting. George Washington, by the way, you notice I never said anything about what I spoke up and said in the Constitutional Convention. George Washington didn't. He wrote a letter to his nephew after a few years after the convention, I think it was 1792. And his nephew was going into the House of Burgesses in Virginia, and he advised him, speak seldom,
Hello, my name is Ralph Shea. I'm a social worker in this community. And a couple weeks ago, I was faced with a dilemma that I didn't have an answer for, and I thought maybe you could help me with it. I walked into our local Social Security office to work for one of my clients who was in need of some service from our Social Security office, and the attending person at the window advised me they needed my Social Security number. Now, I wasn't there for me. I wasn't there. I was told it was because of Homeland Security. Well, I'm there working. I'm doing my job, and I felt an infringement on my rights, my civil rights, to be told that they wouldn't serve me doing my job because I would not give them my Social Security number. That seems to be somewhat Orwellian to me.
Well, I don't know. I don't know anything in the Patriot Act that would relate to that specific question, but there's a lot of regulations out there these days because of Homeland Security issues that are going on, but that one there sounds like it doesn't serve much of a purpose, and I would have to agree with you. You bet.
Other questions? Talk about two more, please.
How you doing?
Good.
My name's Vic Larson, a University of Idaho student. I'd like to ask you to respond to one of the points that Congressman Otter put forth, and that's the definition of terrorism under the Patriot Act. He alleged that the definition has been broadened to include virtually any act that may endanger human life. Don't you feel that that might be overreaching quite a bit?
Well, number one, I don't think the definition is limited to that. But one of the issues that the Patriot Act dealt with was defining who we could investigate, and I think that's what the Congressman was talking about under FISA investigations. The pre-Patriot Act law said the FISA procedures can be used to investigate foreign powers or agents of foreign powers. It was limited to that. One of the problems we have is based on court rulings and court decisions, people like Al-Qaeda, Hamas, Hezbollah are not considered foreign governments or foreign powers. And so we were not allowed to use FISA procedures to investigate those people or their agents. And so the law was redefined to expand it to pick those things up. And I know a lot of people have looked at that language, that redefining language, and says, oh no, that means that you could get somebody other than who we're looking at. But that's the issue there.
Thank you.
Another question, please.
Name's Richard Kochansky. This gentleman's question just prompted a thought in my head relative to the issue of expanding the definition of terrorism because it doesn't affect Hezbollah or it doesn't affect Al-Qaeda, etc. I was just watching the Terry Schiavo business on television where they had special legislation to address her particular case. Now, this perhaps isn't a question for you as a U.S. attorney, but in addressing the question of expanding this terrorism idea, why couldn't Congress then have special legislation to direct the Patriot Act to Hezbollah or to Al-Qaeda without expanding it to cover perhaps the 156 different cases you had previously mentioned?
Mm-hmm.
It might not be a fair question to you as a
Well,
U.S. attorney, though.
you know, I not being involved in the legislative process, I don't know. I'm sure that was one of the issues, because that when you adopt a law like that and you're trying to make sure you don't leave anybody out, there's another type of person. You also, and this was another, I didn't mention this, is they also want to be able to get the lone wolf terrorist, like the Richard Reed, the shoe bomber. I don't think they ever tied him with any specific organization. And yet we want to be able to use procedures to investigate those people who are doing those kinds of things. And so, and it's always a risk when you start expanding definitions, because it's easy to come up with horribles that could occur if it's abused. And I think that is a situation we have here.
Yes, it concerns me that some of the things that it has. Oh, my name is John Gallegos. I'm an employee here at NIC. It concerns me that some of the things that the Patriot Act does include is the fact that we can no longer stand along a parade route and protest against our own president because it's considered an act of terrorism. Stripping our rights of freedom of speech. You think that this is a good thing to have in the Patriot Act? I would like to know if anybody here would like to join me in that question. How can we be stripped of our rights of freedom of speech to stand along a parade route and say that we are against our president or any other politician? The only thing that the videos and other thing gets to show now is people fully supporting this president.
Well, I don't... I don't know of anything in the Patriot Act that prohibits people from
people
protesting.
Were removed from, during the inauguration parade, they were removed because they had signs.
Not knowing why they were removed, but I'll tell you something. If this was an action that was taken under the premise that it was the Patriot Act, they should file one of those 226 lawsuits and get a judge to give them damages for what's happened to them. That is not appropriate, shouldn't be allowed, and I agree with your position on that. That's not hard to deal with.
Mr. Moss and Mark, for Congressman Otter, thank you so very much. And we love to have questions, and we always do at these forums. And I do thank you for always being respectful to different viewpoints, which you are. And I hope you'll be with us at 1 o'clock. For 90 minutes, we'll have another lively discussion at Student Union in the Lake Coeur Lane room. And please come back tomorrow at 10:30 and again at 11:30 with 2 programs here. We deeply appreciate your being here. Thank you.
Such a glaring violation of all the precepts and injunctions of the gospel. Such a savage war upon a sixth part of our whole population. They were men like ourselves, as weak, as fallible, as sinful as ourselves. By their infamous bargain they made among themselves, they virtually dethroned the Most High God and trampled beneath their feet their own solemn and heaven-attested declaration that all men are created equal and endowed by their Creator with certain inalienable rights, among which are life and liberty and the pursuit of happiness. A sacred compact. A sacred compact. What then is wicked and ignominious? People of New England and the Free States, is it true that slavery is no concern of yours? Have you no right to protest against it or to seek its removal? Are you not the main pillars of its support? It is said, if you agitate this question, you will divide the Union. Believe it not. Should disunion follow, the fault will not be yours. You must perform your duty faithfully and fearlessly and promptly, and leave the consequences to God. And that duty is to stop giving countenance and protection to Southern kidnappers. Be assured that slavery will destroy the Union if it be let alone. But even if the Union should be preserved by trampling on the necks and spilling the blood and destroying the souls of millions of your race, we say the risk is not worth the price like this, and it is in the highest degree criminal of you to continue the present compact. A group of congressional leaders have conspired to establish and protect and make safe the insidious and evil and profane system of slavery by passing such diabolical measures as the gag rule, the 3/5 clause, and by reinforcing the fugitive slave law. Among a half a dozen men in Congress, the utterance of whose sentiments in times of great deep excitement command the national attention and exert in all sections of the country a strong influence over the popular mind, for good or for evil, Mr. John Calhoun stands prominent. He has no breadth of character, no greatness of spirit, no generosity of purpose, no comprehensiveness of view. No man has ever been more sectional in his feelings or aims for the country. In no aspect does he present an American front. He is a Southern man as against the North. The welfare of the South, not of the whole American Republic, is the object of his solicitude. The extension and perpetuity of slavery, not the preservation and extension of liberty, is the end of all his labors. Intellectually, it is universally conceded that Mr. Calhoun is much above mediocrity. But a great mind, miserably perverted, is neither an object of admiration nor creditable to its possessor, and is certainly a calamity to the race. The real dimensions of a man are the size of his heart, not the volume of his brain. But who knows what or where is the heart of John Calhoun? Who has felt its warmth? Who can attest to its pulsation? Who knows that it has any vitality? He has no blood. He is as cold as a corpse. He is a man of iron, not of flesh. He is hybridous and not natural. He is demonized by a passion and a principle that destroys all human affinity and undermines every foundation of morality. He believes and acts in accordance with the belief that it is better to reign in hell than to serve in heaven. Washington, Patrick Henry, Thomas Jefferson, all distinguished men of the South, invariably deplored slavery's existence as evil and contemplated its gradual but certain and eventual extirpation. But Mr. Calhoun, in utter disregard of the testimonies of these great men, and in contempt of the self-evident truths of the Declaration of Independence, defiance of the sentiments of the rest of the world, which is still probably low in its estimate of human liberty, and in violence of his natural instincts, still believes that slavery is a blessing, the noblest of all institutions, the source of national prosperity, the cornerstone of the temple of republican freedom. He is resolved to bequeath it to posterity as the richest legacy that can ever be given. If his brain is not diseased to an extent that it destroys all accountability, he is to be judged as the wickedest of men. He is to be ranked as a criminal of no ordinary dye. He goes for the enslavement of millions and their posterity to the end of time, and whatever that bondage requires, whippings, chains, torture, extreme penal laws. He is destitute of virtue, for he denies to these millions the marriage contract and enforces prostitution. He is without natural affection, and he is in favor of wholesale and retail dealing in human flesh, and sells the babes from their mothers as naturally as he would the progeny of swine. He is fraudulent to the highest degree. His proper place, if he is diseased on this subject to an insane degree, then he belongs in an insane asylum and not in the Senate of the United States. But that excuse is not to be greatly urged. Therefore, in a right moral estimate, Mr. Calhoun is deserving of the condemnation we have bestowed upon him. The raid at Harper's Ferry in October of 1859, led by Captain John Brown, and his ensuing trial and execution in December of the same year, is an example and a terrible reminder of the ugly and frightening violence that will always result from the continuance of slavery. A word about the subject of peace. I am a non-resistant, a believer in the inviolability of human life under all circumstances. I therefore, in the name of God, disarm John Brown and every slave at the South. But I do not stop there. If I should, I would be a monster. And in the name of God, I therefore disarm every slaveholder and tyrant in the world. I am a non-resistant, and I not only desire, but have labored unremittingly to effect the peaceful abolition of slavery by an appeal to the reason and the conscience of the slaveholder. Yet as a peaceman, an ultra-peaceman, I am prepared to say success to every slave insurrection at the South and in every slave country. whenever there is a contest between the oppressor and the oppressed, the weapons being equal to both parties, God knows in my heart that my heart must be with the oppressed against the oppressor. Who instigated the deed at Harper's Ferry? The people whose motto is resistance to tyrants is obedience to God, and whose exalting talk is a Bunker Hill and Yorktown. There is a law above all the enactments of human codes, the same throughout the world, the same for all time. It is a law written by the finger of God upon the heart of man, and by that law unchangeable and eternal. While men despise fraud and loathe raping and abhor blood, they will reject with indignation the wild and guilty fantasy that man can hold property in man. I say, let the will of God be done. That is the essence and the comprehension of all my treason. The will of God be done. We cannot acknowledge allegiance to any human government, and neither can we oppose any such government by force. Our country is the world. Our countrymen, all mankind. We love our country and the land of our nativity as only as we love all other lands. The interests and rights and liberties are no more dear to us than those of the whole human race. Hence, we can allow no appeal to revenge any insult or injury. We register our testimony not only against all wars, but all preparation for war, against every naval ship, against every arsenal, against every fortification, against all militia systems, against standing armies, against military chieftains, against all soldiers, against all monuments commemorative of victory over a fallen foe, all trophies won in battle, all celebrations in honor of military exploits, and against all appropriations for the defense of a nation by force of arms, against every edict of government requiring of its subjects military service. We deem it unlawful to bear arms or to hold a military office. We therefore voluntarily exclude ourselves from every legislative judicial body, and then we repudiate all human government, worldly honors, and stations of authority. I will admit I harbored serious reservations and concerns about the election of Abraham Lincoln to the presidency. Though he did not agree with the extension of slavery, he did not promise to exclude it or to end it in the South or to repeal the fugitive slave law. And then, in an act of great courage, he has issued the Emancipation Proclamation. Grant that there are many sad things to look in the face. Grant the whole of justice has not been done to the Negro. Grievances exist which must yet be addressed. Still looking at the question broadly and philosophically, I think the people will ask one question, and that is whether any of them are within one hair's breadth in advance of Mr. Lincoln. I remember the trials through which he has passed, and I remember the perils that have surrounded him, perils unknown to any man in any age of the world. And I remember how fearfully pro-slavery was the sentiment in the North, and to say nothing of the South. When I remember what he has had to deal with, and then remember that Abraham Lincoln has struck the chains from the limbs of more than 3 million slaves, and he has expressed his desire for the abolition of slavery, and he has recognized the manhood and citizenship of the colored population of our country, I do not feel disposed for one at this occasion or any occasion to say anything against Abraham Lincoln. On February 1st, 1865, the 13th Amendment abolishing involuntary servitude was introduced into Congress. And on February 10th, I spoke to a massive crowd celebrating the Jubilee at the Music Hall in Boston. There are no words to express the emotions of this sublime event. The nation, in rising in the majesty of its moral power, has decreed that liberty be proclaimed throughout the land to all inhabitants. Oh, glory, glory, hallelujah. Amen and amen. Oh, give thanks to the Lord, for he is good. His mercy endureth forever. Let everything that hath breath praise the Lord. No man living better understands the joy, the vastness of the change than I do, but truly, I have no feeling of pride or exultation. God forbid. I am unspeakably happy to believe that this assembly and the mass of my fellow man are now heartily disposed to admit that in seeking by all righteous instrumentalities for more than 30 years the abolition of slavery, I have not acted the part of a madman, a fanatic, an incendiary, a traitor, but at all times have been of sound mind, a true friend of liberty and humanity, animated by the highest patriotism, devoted to the welfare and the peace and the unity and the increasing prosperity and glory of my native land. Thanks unto God, that day is here now. Freedom is triumphant. The people have decreed the death of slavery. All the elements of this country are combined for its immediate extinction. And as Jefferson said in his inaugural, we are all Federalists. We are all Republicans. In the sentiment of the anti-slavery that rules the country now, it may be declared, we are all abolitionists. We are all loyalists. And we are moved by one electric impulse to commemorate a radical change in the Constitution of the United States, so radical that whereas for more than 70 years it served as the bulwark for the defense and the sanction and the security of slavery, it now forbids slavery in every part of our republic. And so we come now to the end of this labor and this holy crusade, and I now close out the last volumes and end publication of The Liberator. It has been, without saying, a total labor of love and commitment for 35 years. I began the publication of The Liberator without a subscriber. And I end it, it gives me satisfaction to say, without a farthing, as the result of the patronage extended to it during 35 years of unremitted labor. No journal has been conducted with such fairness and impartiality. None has vindicated primitive Christianity in spirit and purpose, the higher law over nations, and exerted a higher moral influence upon those who have given it a careful perusal. It has excited the fierce hostility of all that is violent and demonical in the land. but it has won the affection and regard of the very purest and noble of the age. To me, it has been unspeakably cheering, and the richest compensation for whatever peril and danger and suffering and defamation I have been called to encounter. There are those who are expressing deep grief in its discontinuance, which overwhelmingly affects my feelings. Let them feel as I do, comforted by the fact that it merely ends our weekly way of communicating with each other, and not to the high principles that we have espoused or to our hopes and our aims for the future. Most happy am I to be no longer in conflict with my fellow man over the issue of slavery. No man of any refinement or sensibility can be indifferent to the approbation of his fellow man if it be rightly earned. But to obtain it by going along with the multitude to do evil, by pandering to absolute power and corrupt public sentiment, is self-degradation and personal dishonor. Better to be always in a minority of one with God, branded as a madman, fanatic, a heretic, an infidel, frowned upon by the powers that be, and mobbed by the populace, or consigned ignominiously to the gallows like him whose soul goes marching on, or burned to ashes like Wycliffe, or nailed to the cross like him who gave himself to the world. Farewell, tried and faithful patrons. Farewell, generous benefactors, without whose essential contributions the Liberator would have long since been discontinued. Farewell, noble men and women who have fought so long and so successfully under God to break every yoke. Hail, ye ransomed millions! Hail, year of Jubilee! Thank you.
And now our next speaker, John C. Calhoun.
Good morning. I'm happy to see you all out here this morning to listen to this debate on American freedom. Unlike Mr. Garrison, I am not ashamed of my country. I am proud of my country. I do admit that my country, as any country, has made some mistakes. But I also maintain that the mistakes that we have made, that we have always endeavored to overcome them. We may not have been completely successful, but we have created the greatest country ever known to mankind. And I think that history will bear me out. I would like to point out something to you, that one of Mr. Garrison's heroes, John Brown, was a radical, was a zealot, and was a murderer. What he failed to tell you, that before John Brown became quite famous at Harper's Ferry, that he murdered a whole family in the state of Kansas in the name of freedom. I don't think that we need that kind of freedom. Mr. Brown and Mr. Calhoun, Mr. Garrison, are radicals. They were zealots. And zealots are the most dangerous people in the world, regardless of their advocacy. My name is John C. Calhoun, and I was born in the Appalachian foothills of South Carolina in the Abbeville district on March 18th in 1782. I would like to give you a little of my background here. I am not here today to defend slavery because slavery in itself is indefensible. But I would like to go through some of my history of my life to point out to you what I did stand for and what I, as John C. Calhoun, advocated for the American government. My father, Patrick Calhoun, was an immigrant from Ireland. His family settled in the northwest area of the Carolina colony. This part of the colony was still inhabited by the Oconee and Cherokee Indians at the time. The fame and wealth of South Carolina was in the Tidewater area and in Charleston. Charleston led the colonies in per capita wealth and had the highest growth rate in the Western world. Charleston was the busiest seaport in the American colonies. Now, my father was active in South Carolina politics. He represented what was called the upcountry, which was in the foothills of the Appalachian Mountains. That area of South Carolina, the people there were looked down upon by the wealthy colonists in Charleston and the Tidewater area. But my father was a man, being Irish, who believed in complete freedom from the government. He disliked even the restrictions that was placed on him or on those of the time of the federal Constitution. I must have inherited some of his desire for freedom, as was shown later in my life. Now, living in this isolated area as I did, education was not readily available. I was largely self-educated until I was 18 years of age. I had only had 2 years at what was called the Log College, which was taught by my brother-in-law, the Reverend Moses Waddell, a Presbyterian minister. I entered Yale University and graduated in 1804. I studied law at Litchfield, Connecticut. I served as a member of the South Carolina legislature in 1808 and 1809. In 1811, I married Floride Calhoun, a distant cousin, who lived in Charleston. Although I was an upcountry man, marriage into this branch of the Calhoun family provided me with entry into South Carolina Plantation Society. The same year of my marriage, I was elected to represent South Carolina in the House of Representatives. Henry Clay from Kentucky was Speaker of the House and leader of a group that was advocating war with England over the interference of American trade with other European countries, especially with France. Many British at the time still looked upon America as a British colony. They were seizing American ships and impressing American seamen who they claimed were British subjects. I was named by Clay to a position on the Committee on Foreign Affairs. As a member of this committee, I supported Clay in the precipitation of the War of 1812. The war lasted until 1815. In 1817, James Monroe, who had served as Secretary of State under Madison, was elected president. I had worked closely with Monroe in the House of Representatives. We subscribed to much the same policies concerning the defense of the country. Therefore, he appointed me Secretary of War. I served in this capacity from 1817 to 1824. John Quincy Adams was elected president in 1824, and I was elected vice president under Adams. At that time, vice presidents were not elected with the president. They ran on their own. Sometimes they were even from different parties. And it wasn't up until 1804, vice presidents did not run as vice presidents. The two highest vote getters in the presidential race was named president and vice president. But the first person elected as a vice president was a man named George Clinton. He was elected to serve with Thomas Jefferson. In 1828, the very popular soldier, Andrew Jackson, was elected president. And again, I was elected vice president. Now, I did not get along very well with the Jackson administration. Jackson was an imperious, inflexible, and an unforgiving person when he perceived that he was being opposed. It was no secret that I had ambitions to be president, but so did Martin Van Buren, who was Jackson's Secretary of State. Van Buren and I were not the best of friends. I thought I had good political support from the southern states and from Jackson because we were both natives of South Carolina. I also had strong support from Pennsylvania. Van Buren set about to undermine me with Jackson by bringing up an old issue that had taken place when I was Secretary of War. Jackson had become Major General of the Tennessee Militia. When the War of 1812 began, he raised 50,000 volunteers from his state, and he was given a command in the field. The enemy whom he marched against was not the British, but the Creek Indians, who were allied with the British and were threatening the southern frontiers. Jackson crushed the Creeks to the extent they were forced to cede to the federal government about 1/5 of the state of Georgia and 3/5 of what later became Alabama. Jackson, without authorization, attacked the Spanish fort at Pensacola, and after the Battle of New Orleans, invaded Florida. This brought protests from Spain and placed the United States in a position of endangerment by retaliation. There was a movement by the Monroe administration to censure Jackson. As Secretary of War, I was involved. But Jackson had become such a hero to the people that it was considered impractical to censure him. Van Buren brought to Jackson's attention my involvement in the incident. This aroused Jackson's ire, and being of the type of temperament he was, this made him a lifelong enemy. Still the hero that he was to the people, especially in the South, when he, through his support to Van Buren, destroyed any chances I had for being nominated for president. Everyone who holds public office creates enemies regardless of how great is his integrity. The one thing that caused more opposition to my policies was the support I gave to nullification. This was an attempt to allow states to nullify any law passed by Congress that they considered unfair and detrimental to their area. At that time, slavery had become a big issue. This was used against me by my opponents as a reason for my support of the Nullification Act. This was completely untrue. My views on slavery had been established in 1812. I wrote an apology for my section's support of slavery. I wrote, "It covers me with confusion to name it here in regard to the compromise in the Constitution permitting the slave trade to continue until 1808. I feel ashamed of such tolerance and take a large part of the disgrace as I represent the Union by whose influence it might be supposed to have been introduced." Mr. Garrison, in his tirade against me, failed to point that out to you. I never was an advocate of slavery. My support for nullification was because of what I and many others in the South considered an unfair export tariff passed by Congress that benefited the northern states and was detrimental to the economy of the South, which was greatly dependent on exports of cotton and other commodities to Europe. The New England manufacturers were not affected by the export tariff because they exported very little abroad, depending on the fast-growing population in the states. The southern economy began to decline while the northern states was enjoyed an increase. I did not believe then, nor do I believe now, that the writers of the Constitution intended for any one area of the Union to profit at the expense of other areas. Nullification was a long and bitter battle which caused a great deal of unrest in the country. At the time, attitudes were more regional than national. Communications were slow, sometimes non-existent. Therefore, the populace was uninformed of happenings outside of their immediate areas. This resulted in much stronger feelings for one state than for the entire nation, much of which they knew very little or nothing at all. The abolition movement had become quite vocal in some of the northern states, especially in New England. This added to the tensions between the North and South. Slavery in America did not originate in the South, as many believe. The British and French and the Dutch introduced slavery in the West Indies, Spain and Portugal in South and Central America, long before the United States existed. Britain brought slaves to North America in the 17th century, first to New England, not to the southern states, because New England was the first to develop. They soon found New England was not well suited for slavery. Those that proved to be adaptable as house servants were kept, And in Mr. Garrison's time, there were still slaves in the New England states. But slavery did exist in the northern states. It was not profitable to keep slaves on the small farms of the north. The larger plantations that began to develop in the south was more suitable for slave labor. After the invention of the cotton gin in 1793, slavery became more progressive in the South. The abolition movement had begun in New England even before the Revolutionary War, but was rather ineffective, as the British paid little attention to the wishes of the colonies. As slavery increased in the South, the abolition movement increased in the North. But not everyone in the North was an abolitionist. And I'm sure that Mr. Garrison will attest to that, because Mr. Garrison himself was attacked by a mob and was severely injured and almost killed and had to be put in jail for his own protection. Now, this did not happen in the South, unless it was South Boston. It happened in the New England states. But similarly, everyone in the South were not in favor of slavery. Only a relative few, approximately 1% or less, that owned slaves, because most of the inhabitants of the South could not afford to own slaves. And those who did not actually suffered under the consequences of slavery. It is quite likely, if it had been decided by ballot, slavery would have been abolished in the South. The resentment in the South was to the tariffs, which eventually led to movements of secession. I was heartily opposed to secession, or disunion, as it was called in those days. I did not support dissolving the Union. I did support nullification as a weapon against tariffs that were detrimental to my state. This, in my opinion, was supported by the 10th Amendment, which states, "The powers not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively, or to the people." My interpretation of the 10th Amendment is that nullification was legal because there is nothing in the Constitution that opposes it. The first threat of disunion came not from the South, but from New England. This was opposition to a tariff to build roads and canals throughout the nation for defense purposes. New Englanders did not believe they would benefit from these endeavors. Therefore, they objected to being taxed to help pay for them. They threatened to secede from the Union if it became law. The tariff was defeated, and the New Englanders withdrew their support for secession. The differences between myself and the Jackson administration increased over the Nullification Act to the extent that I found it necessary to resign as vice president. I was replaced by Martin Van Buren, who later became president. In 1833, I was again appointed to the U.S. Senate. In those days, senators were not elected, they were appointed by state legislators. I served in the Senate for the next 17 years, except for a brief period in 1844 and 45, when I served as Secretary of State under President Tyler. By 1850, I recognized the North and South were virtually two separate countries, and that only force, military or legal, could compel the North to recognize Southern rights. I did not specifically advocate nullification or states' rights, but I believed the great economic interests could only be safeguarded regionally. And I sought legislation that would restore the lost equilibrium between the two sections. In 1850, I had become ill. I made a last appearance before the Senate. I made this statement in my last speech. The dissolution of the Union is the heaviest blow that can be struck at civilization and representative government. To the end, which came March 31st, 1850, I clung to the Union. Thank you.